the property management industry, fair housing offenses are considered especially troubling. In the United States, a dedicated fair housing attorney, Leslie Tucker, provides case explanations and best practices. These are some cases.
Hello, everyone. Welcome to the Fair Housing Insiders Case Files. I'm Jonathan, your host, and today we're diving into a case that highlights two common but critical areas of misunderstanding in fair housing: emotional support animals and the rules surrounding documentation and fees. So joining me is Leslie, a fair housing attorney from Williams, Edelstein, and Tucker, and she has extensive experience in these topics. So Leslie, welcome to the show.
Thanks, Jonathan. Appreciate it.
So this is a pretty big case. I know in general for this channel, anything that has to do with assistance animals, emotional support animals, they're one of the most popular from our viewership. So we're grateful to dive into a very specific case. Today's case is United States versus Gregory Estates, LLC. And this case explores allegations of discrimination based on disability, centering on the alleged mishandling of an ESA request and focusing on a property manager's demands for excessive documentation and attempts to charge fees for the emotional support animal. So could you give us an overview, summarize the case for us? What are we looking at today?
Sure, yeah. This case involves a tenant, Patrick, who was a trucker. And he initially obtained a dog to travel with him while he was on the road for long periods of time. And during the period of time that he was home and not on the road, the dog would stay with his ex-wife in a different location. Mm-hmm. So the dog didn't technically reside with him and sleep, in his apartment. However, so Patrick got into an accident, a trucking accident, and therefore he was home for a while. And he had this dog stay with him for one of the nights that he was home. Of course, the dog was immediately discovered, and his property is a no pet property. So the property manager instructed Patrick to get rid of the dog, and so Patrick did. He got rid of the dog. About a month later, since Patrick wasn't cleared to go back to work, to drive again, he was going to be home. So he asked the property manager for a reasonable accommodation to reside with an ESA. Not the same dog, but he was going to get a different dog to come live with him. He provided a letter from his primary care physician stating, that he has a disability, kind of explaining the need for this emotional support animal. The property manager, Mr. Gregory, insisted on some additional documentation aside from just this letter from his PCP. What he was requesting was what he referred to as an ADA document, and as well as some kind of proof that the dog had been trained. Neither of these things, as many of you probably know, are required to be approved for an assistance animal under the Fair Housing Act. Furthermore, the manager also informed the tenant, Patrick, that he, was going to have to pay a fee, a deposit, and a monthly pet rent, which many of you know, you cannot charge for an approved ESA. So the manager basically told Patrick, look, after you give me this ADA document, which it was never really explained what he meant by that. It was just sort of, I need an ADA document and proof of training, then you'll be able to bring this dog that has been specifically trained for your disability. Patrick, kind of pushed back on these demands, saying, what are you talking about? I don't know what you want. This is not required. But ultimately, when he was unable to provide whatever the manager was looking for, the accommodation request was denied and his lease was terminated. So he did have to vacate the premises. And throughout this entire process, Patrick never did obtain another dog.
Yeah, that's crazy and concerning. It seems like this is a clear example of how misinformation about documentation and fees, it's clearly a violation, right? What are your thoughts?
Yeah, I mean, and the issue about what documentation can I accept, what can I reject, a lot of landlords do have confusion about this. So it is
Right.
understandable that, not everyone is going to be an expert on this. But the Fair Housing Act does explicitly prohibit a housing provider from charging fees for an ESA, for an assistance animal, or imposing requirements that kind of go beyond reasonable documentation. So what is being alleged in this case would amount to a violation of the Fair Housing Act, and potentially, liability.
Okay. Very good. Thank you. So what are the key legal issues in this case, and how did the property manager's actions violate fair housing laws?
So there are three primary issues. One is just, kind of understanding reasonable accommodation requirements. Housing providers are required to provide individuals with disabilities reasonable accommodations. And this would include waiving a no pet policy, waiving fees when it comes to assistance animals. Okay, the second is about documentation. When you are reviewing a request for a reasonable accommodation, what are you allowed to require, and where kind of can't you go? A letter from a qualified healthcare provider that outlines, the disability status and the need, that's really sufficient. And additional documentation like proof of training, an ADA document, registrations are just not required when it comes to assistance animals. And of course, the prohibition of fees, right? We talked about the fact that when it comes to assistance animals, you cannot charge these types of fees. And these are just things that housing providers have to know to operate rental housing.
Yeah, very good. Nice breakdown for us. So it really sounds like the way that this manager acted, it just created one barrier after another for this resident. So what are some practical steps then? So our audience, they're on the edge of their seat for cases like this. What can a property manager do to avoid issues like has been demonstrated in this case?
Sure. And of course, I just want to make the obvious point for those who may not know is that these are certainly allegations. This case is ongoing, and I certainly can't make any sort of determination as to whether the allegations are true or not. But these are just sort of the facts of the case. Some actionable steps that we can kind of learn from these allegations are the importance of educating yourself and your team. Everyone who works at a property that deals with these types of requests need to understand the distinctions between ESAs and pets, as well as the rules for documentation and fees for ESAs versus pets. When it comes to assistance animal requests, your staff needs to be aware of what type of documentation is acceptable and who to ask if you just don't know. Because that's certainly possible too. There might be confusion. Who do I go to get a clear answer? Another important action to take is to make sure that you have updated policies, specifically animal policies, to ensure that you have kind of separate agreements, separate rules for pets versus assistance animals on your property. And third, consulting with an attorney or a compliance professional to make sure that your policies are in line with fair housing laws is a must.
Right. Good takeaways, good actionable steps for our audience to keep in mind. So thank you for those recommendations and being able to give us a little glimpse into this case, why it's so important for our audience. Has been an amazing discussion. Thank you.
Thank you, Jonathan.
And for our listeners, we want to thank you for tuning into the Fair Housing Insiders. We are grateful to bring these case files to our audience. Don't miss out. Make sure you subscribe. Please share this with your network if you find this valuable. So until next time, good takeaways for all of us to be fair, compliant, and make sure that we're doing all that we can to have inclusive communities. So take care, everyone. See you next time.